Thank you very much for inviting me, and congratulations on organising so successful a conference. I am a professor of law and psychiatry by night, and an advocate at Queen's Counsel in the courts during the day. I became fascinated by why people engage in a variety of forms of scholarly misconduct, and in particular, research misconduct. Klaus, you didn't refer to the book that was written by Diederik Stapel. It is one of the most interesting books I have ever read. I don't encourage you to read his scholarly writing, given that it is now somewhat debased in its coinage. And I'm not sure I want to encourage you to pay money to read his book. But let me just read you a little passage, because it is so important for us to understand why the small number of people who behave so badly do so. Let me read to you about him. He said, "I started to be unhappy with my complicated and not particularly elegant message. I was bored with the unimpressive assortment of tiny effects and barely significant results that I'd assembled over time. My work received plaudits, but always in terms such as professional, conscientious, interesting. What I produced was never described as beautiful, brilliant, elegant, powerful, or fascinating. I built on what others had discovered, but I was never at the start of a chain of research. I was always at the end. I published all kinds of things, but for whom? My minor artisanal discoveries were too trivial to make it into textbooks, and my theories were too dry for anyone to want a chapter on them in the handbook they were editing. At conferences, I was still in the small to medium rooms off to one side. I'd never been invited to be the keynote speaker. I wanted to come up with a line of research that everyone would want to follow." He's a very articulate writer. There's minimization and denial and rationalization in his book, in English titled The Derailment, but it's really interesting in terms of getting you into the mind of someone who has behaved so unethically for such an extended period of time. My task is to canvass with you whether one of the useful interventions that can be undertaken is criminal prosecution of those who have engaged in egregious research misconduct. The criminal law, of course, is deployed by the state in order to punish, to deter, and most particularly to protect all of us. We have other mechanisms in all of our countries to endeavour to compensate those who have been adversely affected by the criminal behaviour of others. And there'll be a session tomorrow which is particularly looking at some of those sorts of issues in respect of victims, and especially a United States initiative under the False Claims Act. I'm going to concentrate on research misconduct and the criminalisation of it. Using the definition of the Office of Research Integrity, my focus will be on outright fabrication and falsification of research. Although it may be uncomfortable for many of us, the law is around and about responding to, being manipulated by, sometimes being abused by and responding to research misconduct. There are prosecutions, we'll talk more about those. There are appeals, there are judicial reviews, injunctions are taken out to try to stop investigations. People are dismissed from their employment. Defamation actions are threatened, sometimes they're brought. Disciplinary action is taken affecting people's entitlement to be registered, for instance, as a medical practitioner. Harassment and discrimination actions are brought, and compensation actions, to which I've already made reference, circle as potential sequelae of the conduct of those who have been responsible for research fraud. What I'd like to do is to contextualize research misconduct within the criminal law for you. In many respects, it is just another form of white-collar crime, undertaken by those who are privileged and empowered. It's done premeditatedly. It has foreseeably adverse consequences, and we'll look at some examples of that. It's undertaken for one kind of direct or indirect gain or another. And it is fundamentally, deliberately dishonest. It manipulates and exploits funding opportunities, amongst other things. In a rather interesting book called The Death of Expertise, published just this year, Tom Nichols talks about mendacity by experts, experts upon whom the community wants and needs to rely. And he says this: their threat to expertise comes in both the immediate outcome of their chicanery and the erosion of social trust. The betrayal is in part of society in the broadest sense. Now, Julian McCrane has argued passionately that it's best to keep the law, and probably lawyers, right away from discourse about research misconduct. He says that criminalising it is a sad, bad, even mad idea that will only undermine the trust that is an essential component of research. He says there are other and better ways of dealing with the phenomenon. What I'd like to do with you just briefly, and I'm going to take you through a journey through some of the most notorious international cases where people have been prosecuted for research misconduct, is to see what we can learn, what patterns we can identify, because it's by doing this that we have the potential to identify those who might be minded to behave in a similar way, and it's in this way that we can start to formulate strategies and responses, and perhaps some of them will work. Stephen Browning was the start of prosecutions in the modern era. He was a very prominent researcher on Ritalin and Dexedrine for ADHD, and notoriously Professor Sprague, perhaps one of the most famous of the whistleblowers, from the University of Illinois, already a very eminent professor, identified curiously perfect agreement in various of the ratings. Ultimately, through his pressures, investigations were undertaken, and a review found that only a few of the experimental subjects described were ever studied at all. His fraud was whole-scale. He was caught, thanks only to the persistence and commitment of Professor Sprague. He found himself ultimately, that's Stephen Browning, in the District Court of Maryland. He pleaded guilty to a variety of charges. He was convicted, he received a lengthy period of probation, and he was ordered to repay various monies, and he agreed not to take work as a psychologist for a significant period of time. It's a long time ago, just on 30 years, but it was the start of a new form of responsiveness to this kind of conduct. Everyone knows about the person who created Snuppy, the clone dog, Wu Sakwang, high-profile veterinarian, professor at Seoul National University. He claimed to have created human stem cell lines, and the potential for his work seemed to be enormous. The trouble was, it was fraudulent. He admitted it in 2006, and he was found guilty of various criminal offences and sentenced to jail. But it was jail that was suspended. He appealed, and then he appealed again. Ultimately, the sentence with which he was left was a period of imprisonment, albeit wholly suspended, so he did not need to spend actual time in jail. But the denunciation and the public opprobrium which his misconduct generated when it was exposed was significant indeed. But some of these people are extremely resilient. This is what he said about his conduct. He said, "I created an illusion and made it look as if it were real. I was drunk in the bubble I created." But he's kept going. He's continuing to get funding. He's continuing to do cloning experiments. and it is said that he is making a major comeback in the world of cloning research. Eric Pullman in the United States was a physiologist who published very extensively on a range of issues to do with obesity and aging. Internally, I apologize for the extra a researcher found anomalies in his data. His propensity was to take home his data and work on them there, and refashion them, refabricate them, and falsify them. Ultimately, a university investigation found his fabrication of data was to enhance his reputation and yield him further opportunities for publication and for funding. He was charged. He pleaded guilty to falsification and fabrication in a considerable number of articles over the better part of a decade in federal grant applications, and he was sentenced to a year's imprisonment, as well as a significant period of probation. He said, "I was motivated by my desire to advance as a respected scientist. I believed it was legitimate to misrepresent minor pieces of data to increase the odds." Now, can you see already a bit of a pattern? The capacity for rationalization and justification for the greater cause. I started with Starple, we're now at Pullman. Judge Sessions, however, would not have any of it. He said, and they're good words, important words, declaratory words, "When scientists use their skill and their intelligence and their sophistication and their position of trust to do something which puts people at risk, that is extraordinarily serious." Is there anyone here who would disagree with that? No. Luc von Paris, an associate professor at MIT, a neuroimmunologist, fabricated his results for some 7 years. He too found himself before the district court in Boston, pleaded guilty. He received a significant period of home detention, community service, and repayment of monies. But it was Scott Rubin in the modern era who really impacted upon the consciousness, I think, of all of us. He was an important and high-profile proponent of multimodal analgesia therapy, and there are other options, of course. He was heavily funded by a variety of private sponsors. He was a professor at Tufts University Medical School and director of pain management at Bay State Medical Center in Massachusetts. Doubts started to surface about the propriety of his methodologies and whether he was fashioning his claims and his analyses and then his data in order to support the multimodal analgesia therapy whose merits he propounded. By 2008, what emerged was that he had engaged in fraudulent conduct in 21 clinical trials over a period of well in excess of a decade. He claimed not to have been motivated by greed. He said the funds that he got went to his employer and his conduct was attributable to bipolar disorder. You'll hear that refrain from a number of the persons who have been charged. He was sentenced to a period of imprisonment and then a significant period of supervision and ordered to pay a substantial amount of money in restitution. There's been very little by way of prosecution in the United Kingdom. The one example is under an obscure piece of legislation in Scotland in relation to a man who manipulated drug trial results for a drug company over a period of some 6 years. He faked his results and he selectively reported them. He said he'd been under a lot of pressure. He said he hadn't profited personally. He was sentenced to 3 months jail, and the laconic comment by Sheriff O'Grady, the judge, was, "You could have caused cancer patients unquestionable harm." Craig Grimes, to go away from the biomedical area, was a professor of material science and engineering at Penn State. He worked on the conversion of carbon dioxide into energy, a very important issue, now that we're understanding the phenomenon of climate change so much better. His work was persistently fraudulent. He obtained large amounts of money from state funders. He said he'd been zealous because he'd been wanting to help the world. He received 41 months of imprisonment, so that's well over 3 years. Substantial amount of money, significant time in jail. Let me refer to an anomalous case involving Christopher Gillberg, a professor of child and adolescent psychiatry in Sweden. He's a world-acknowledged expert on autism and ADHD. He was the subject of allegations, possibly brought for collateral motives. It's a complex case. But in the course of this, he proclaimed that he was not prepared to release his clinical files, and he had a variety of reasons because he was troubled by the involvement of Scientologists in the claims against him. Ultimately, he destroyed those clinical files after a court had ordered him to make them available. He was charged in the courts of Sweden and fined for his conduct, as were others, and he appealed to the European Court of Human Rights at the trial chamber and then in the appeals chamber, and he lost all the way along. So it was a strange involvement and an anomalous one in respect of a man who continues to command the highest of scholarly reputations. Dong Pyu Han's tale will be well known to just about everyone here. Part of a groundbreaking team in doing AIDS research in respect of which so much optimism was harboured. He confessed to spiking rabbit blood, ultimately with human antibiotics, as part of a large federally funded trial. He'd been an assistant professor at Iowa State University. He resigned, he was charged. At first, suspicion in respect of what had gone wrong here fell on a variety of others. He said he couldn't bring himself to dash the hopes of his research team. He said he didn't get any extra funding, he just got kudos. He also received 57 months of imprisonment. A huge amount of money was ordered to be repaid, and he will likely make his way back to his native Korea. Milena Penkower in Denmark also suspended for a variety of embezzlements involving rat experiments. Multiple of her papers were retracted. She received a 9-month suspended sentence. On appeal, a technical anomaly was found, and her sentence was quashed, although her fraud was acknowledged as proven. There have been 2 examples just latterly in Australia as well, both of them involving persons working for the Centre for Neurogenic Communication Disorders Research at the University of Queensland, doing work on Parkinson's disease. Again, fabricated data. One of the unusual things in this was that the 2 people worked together. It would seem they no longer get on so well, and they've been accusing each other of being more responsible for what occurred. Both claimed to have been suffering depression. The fraud of the female, Carolyn Barwood, was described by the sentencing judge as brazen, unscrupulous, and persistent. Many people have not been charged. Haruko Obokata, whose supervisor committed suicide in the aftermath of her fraudulent behaviour being exposed. Many others whose names are there, and there are only a small selection of persons who might have been charged but weren't. Many of whose articles have had to be retracted in leading scholarly journals. And Diederik Stapel wasn't criminally charged ultimately. Well, it didn't proceed, I think, did it? He entered into an arrangement whereby the courts were not seized of it, and he made some appropriate concessions and was obliged to repay some monies. So why do these people do it? This is as good an analysis as I've seen. It's not a homogeneous explanation. People are different. Some are early career people. Some are more consolidated researchers. Sometimes they have personality disorders and weaknesses, often vanity and arrogance, sometimes a desperation for kudos and attention. Some occupy prestigious positions and are charismatic and impressive. Grandiosity and narcissism are frequently prominent, but what is common is an indifference to the effects of what they're doing, a prioritizing of their own circumstances over the impact upon others. Often they're highly ambitious, extremely productive, obsessive in the workplace. They don't take being complained about or exposed well, and they often go on the front foot aggressively to defend themselves against accusations. What they do is dishonest intellectually, and there are multiple victims in respect of their conduct. Lex is criminal prosecution, the answer? No. But perhaps it is part of the armamentarium of responses. We've heard sophisticated approaches and reforms from the first two speakers. My talk is not so sophisticated. I do say that the conduct engaged in by the kinds of people whose work I have described is unforgivably intellectually dishonest. It hurts their colleagues. It runs the risk of propelling research trajectories which will have an adverse outcome, for instance, on patients. It tarnishes institutions. It damages whole trajectories of what may be legitimate research and the impact upon colleagues, students, supervisors I have adverted to. It is not a victimless crime. Prosecuting these people is not a panacea. As Gaiman said a few years ago, the law is a blunt instrument. It's not a scalpel, it's a club. But sometimes clubs have a purpose. Carrots are excellent, but unfortunately, many of those prepared to engage in the unethical conduct to which I have referred are far from being rabbits. However much encouragement you give them, however nice and juicy and tasty and fresh the Dutch carrots are that you lay in front of them, they're going to do it anyway, unless they have every reason to fear that they're going to be caught and that the consequences are going to be catastrophic for them. Criminal prosecution, as I've said, is no complete answer. It can be slow, it can be stressful. Not all of the people who might be, should be prosecuted are prosecuted. The focus is on dishonesty rather than on the lack of ethics in their conduct, and the approach can be punitive. Some people say the consequences are too harsh, some say they're not harsh enough. But to conclude, it does seem to me, and I'll be fascinated to hear what you think, that there are real advantages on occasions to the deployment of criminal charges which go to judgment. There's a declaration by an institute of state, a court, that what they have done is wrong. It names them, it shames them, and there is a real potential for deterrence in that. The punishments have tended, as you can see, to be modest with some exceptions. The 41 months jail, the 57 months are obvious exceptions. But then again, the conduct is really bad. If it was theft from a bank or large numbers of break-ins on people's houses in which substantial amounts of goods were stolen, again and again and again over years, the periods of imprisonment would be substantial in most of our countries. And the offenders here are not drug-addled persons from deprived backgrounds. They're elite, privileged, highly educated people who live well. Their victims are multiple. The funders need to be protected and they need to be vindicated, and so do the victims, their colleagues. And we need to do what we can to protect patients and others by an effective form of deterrence. And perhaps most importantly of all, given the harm that those who engage in research misconduct do to the fabric of our professions, and even to society itself by their abuse of trust and their betrayal of us, it seems to me that the criminal law has a role. It's not going to fix everything. Its deterrent impact, Lex, I cannot evaluate empirically, but the message radiates out, I suspect, in a powerful way, and perhaps it has a part to play. Thank you.
Well, thank you very much for this nice lecture. I learned a lot. Are there any questions from the audience?
It's almost time for dinner.
Yeah, possibly, possibly. I've got one question that is burning a little bit for me. When you read the literature and when you talk to criminologists, they always say the same. The likelihood of getting caught in science is way too low. What is your opinion about it?
The likelihood is low, and those who do it well, and most of those whom I described did it very well for a long time, fabricate their data almost completely. And that's one of the best ways of getting away with it. I think we're seeing a shift. I really believe that the Stapel investigation and the momentum it's given to more rigorous processes has radiated out well beyond the Netherlands, and that the potential for getting away with it for very long is dropping. Okay. And it's a combination, I think, of the chances of being caught and the really unpleasant consequences that flow if caught that are part of the answer to deterring people.
Thank you. There's one colleague who wants to ask you a question.
Yes. May I add, I'm Roel Verenhout, chair of the Netherlands Board of Research Integrity. May I add one other disadvantage of a criminal attitude of a criminal prosecution. Criminal prosecution is directed to the person itself, and it leaves outside the institutions. Yes. And in my opinion, scientific integrity is first and almost matter of the institution and a concern of the institution. And that's why I'm not in favor for criminal prosecutions.
Your point is so important, isn't it? Because these behaviours tend to take place in institutions which are permissive, where the kinds of constraints that ought to be present are weakened. But most people who work in even those permissive institutions where the potential for bad behaviour exists don't engage in it. And there's a high level of moral culpability on the part of those who are prepared to seize the chance opportunistically to betray their colleagues, their ethics, and their discipline. And I think it's important to identify the environment which needs to be enhanced and remedied sometimes, but also to affix with genuine responsibility those persons who make the bad decisions to their own advantage. Yeah. We don't disagree.
Yeah. Thank you again.
Thank you.